A $2 billion lawsuit accuses Manitoba and Canada of trampling the rights of First Nations to govern their own child welfare matters, instead apprehending yet another generation of Indigenous children in the 1990s and 2000s, known as the Millennium Scoop. In a nearly 400-page ruling, Manitoba Chief Justice Glenn Joyal said the defendants, through the manner in which they funded, regulated, and provided child welfare and protection in Manitoba, unjustifiably infringed on the plaintiff's Section 35 right. The judge went on to say, despite decades of public reports imploring change, policies and legislation didn't follow, perpetuating a system that disproportionately focused on apprehension of children instead of appropriate preventative services, even though most cases do not involve allegations or suspicions of child abuse.
This decision confirms what our nations have known all along, that Manitoba and Canada's child welfare system contributed to the gross overrepresentation of First Nations children in CFS.
For too long, First Nations raised these issues and were ignored while more children were taken from our communities.
Taking Indigenous kids from their families has been costly for Canada. From residential schools through the 60s Scoop and the 2023 federal child welfare class action lawsuit, settlements total around $40 billion. It remains to be seen how much the Millennium Scoop will cost. The judge in this matter didn't make a decision on damages.
I hope that the provincial and federal governments will not continue fighting us in court.
In 2020, Parliament decided to give control over child welfare back to First Nations, Inuit and Métis communities to operate it by their own rules. But the handover process has been slow. There's only 19 communities that have their own child welfare systems, while hundreds more are still in the process. Melissa Ridgen, Global News, Winnipeg.